All right. Let's get underway, please. House Bill 1031 is being withdrawn by Delegate Healy. This is a House Judiciary Committee. It's March 16th. We're having a voting session. It's a little bit before 3 o'clock, and we're starting with House Bill 1031. Delegate Healy is seeking to withdraw the bill. There's a motion for an unfavorable withdrawn, and a second. All in favor of the unfavorable, say aye. Opposed, nay. The bill is withdrawn unfavorably. We start now with House Bill 42. House Bill 42, Delegate Lopez's bill related to bankruptcy. There are amendments. Could I have a motion on the amendments? Motion on amendments. Second. All right. So here, could we have some insight as to what the amendments do, please? Holly. Holly's coming.
Clarify the definition of depository institution. They clarify the procedures and the parameters that must be followed when exempting the $500, and are technical. And that's it.
Are there any questions about the amendments? It appears that there's peace in the valley now. These mimic the amendments that were added on in the Senate. Is that right? We moved the amendments, and there was a second. Any further discussion on these amendments? Seeing none, all in favor of the amendments, raise your hands. Anybody opposed to the amendments? No one. Amendments are adopted. We're on the bill as amended. There's a motion for a favorable and a second. All right, and a third. Is there discussion on the bill as amended? Seeing none, we'll go ahead with a roll call. The Vice Chair. Yes. Munoz. Yes. Crutchfield. Yes. Cardin. Yes. Bartlett. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. No. Simmons is excused. Boucher? No. Phillips? Yes. Tomlinson? No. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? No. Young? Yes. Valentine? No. Conaway? Yes. Kaufman? Yes. Williams? Yes. 15. Favorable with amendments. We now go to a bill that if you would have told me that there would have been global agreement, I might not have believed you, but apparently there is, and it's evident through a couple phone calls that I've had. House Bill 193. This is a bill that creates a new structure for probation before judgment in some cases. Did somebody want to talk about, we did not send this to subcommittee. Claire, do you feel comfortable talking about the amendments? Okay, so Claire will talk about the amendments to the, well, let's do this while she's getting set up. There's a motion for the amendments and a second. So we're on discussion of the amendments. Tell us what the amendments do.
So the amendments just kind of rewrite the language of the bill, and they authorize the entry of probation before judgment pursuant to an agreement between the state and the defendant in which the defendant pleads not guilty and the court finds facts justifying a finding of guilt.
Are there questions that people have regarding this? Delegate Grammer.
Thank you, Mr. Chair. So if I remember the impetus of the bill, this was Delegate Winika Fisher's bill, if I'm not mistaken, and a big part of the history behind the bill was we were having cases of immigration where probation before judgment still rendered those people subject to deportation even though they received probation. Is that correct? And how have we changed this to appease all of the interests?
I think the big thing that was done was that the state has to agree. So I think one of the concerns, there was sort of a broader due process concern of could a defendant come in and just say, I'm going to plead this way and seek this disposition, kind of have a little bit of no guardrails around that decision, requiring the state at the beginning to say, no, we agree with this, and effectively creating a process where the disposition itself is delayed. So a PBJ now has this sort of legal quirk where a person is given a conviction, a person is convicted and then instantly that conviction is taken away. What this does is, in this case, they don't get the conviction at all. The court just basically puts it into stasis. They do what they're supposed to do during probation, and then the case goes away. Or if they don't do what they're supposed to do on probation, then they have to deal with the conviction. My understanding, not my understanding, what the bill also says is if they violate their probation, then they've waived their rights to appeal. They've raised their right to a further trial. They waive their right to trial altogether. So that's part of the deal here is they give up their right to trial. And so if they don't do what they're supposed to do, they're looking at a conviction and the consequences that come from that.
So in response to an attempt to make the bill workable, we've changed the structure of the probation before judgment.
It makes it so that the state has to object at the beginning to that process. If the state objects, then they can't go forward with this, and that I think has made the state's attorneys more
So not only can you plea into the probation before judgment, but it would apply the probation before judgment to really, I guess, any PBJ going forward for any crime. Is that correct?
It could be theoretically for any crime, but the state would have to agree to go along with it.
Okay.
Which also I think, and that's consistent with what was done with this. Virginia has had this, and has had the state having to engage in the process. I think it puts a bit of a barrier for more serious cases. I think if it's used, it makes it more likely to be used on lesser cases, much harder to be used in a murder or a rape. You would not use this, I don't think, in this case.
All right, thank you.
Delegate Tomlinson, then Phillips.
I appreciate you. Thank you, Chairman, for explaining that. Under this bill, you said that if the probation is completed, it goes away. When you say goes away, what do you mean by that?
They would dispose of the case. I think the idea here is it allows them to complete the conditions of the probation, whether it would be obeying all laws or maybe completing a treatment program or paying restitution or any number of different things. They could do all of those things. If they didn't do them, they'd be looking at the conviction and the conviction on their record at the back end. But what this does on the front end is if they did all of those things, they successfully completed it, then the court could say, okay, we're done. You don't have, there's not a conviction that's going to appear on your record. There's not a PBJ that's going to appear on your record. This case just goes away. But again, the state has to the state doesn't have to affirmatively do it. The state has to not object to the use of this mechanism for it to work.
All right, thank you.
Delegate Phillips.
I think you touched on I wanted to have some clarity. This puts us in par with what Virginia perceives as the PBJ. It gets us out of this issue where the feds might say it's not really a PBJ, therefore there was a conviction, and therefore as far as the federal courts appear, they handle it as if it was a conviction. Because there isn't a conviction, what the federal courts were doing was looking and seeing even the 5 milliseconds that there was a conviction, they're saying
boom, there's a conviction. Even if they take it away, nope, there's a conviction. That impacts that person's immigration status and impacts their immigration status forever.
It also impacts their gun status, right?
It would impact,
The ability to.
it depends. Yeah, again, it depends with what kind of crime and a lot of other things, but it could impact other things. So this would be a way for them to avoid the conviction.
Would it also potentially impact federal employment?
I mean, it could. It would mean that, again, what you're doing is you're avoiding a conviction being, if the question is, have you ever been convicted of a crime, you would not have actually been convicted of a crime. The judge would have been able to say, I think that there are facts sufficient. The normal thing that they would do in the litany is to go to the next step and say, there are facts sufficient and I find you guilty. They just would stop there and they'd defer that finding of guilt until a later date unless they did what they were supposed to do. That's the idea around this. One moment, please. So just the question that here is whether it would stay on their record as a probation before judgment. I do believe that in the reading of the bill, it would stay on their record as effectively a PBJ for the purposes of law enforcement and everybody. And in the cases, if this were used for a DUI, it would still appear for that. So there would still be expungement questions that would need to be addressed. But for the purposes of them having a conviction, it would manage to get around that problem. So people would still be able to know that they had gotten probation in the past. They would be able to skip over truly skip over the conviction part. One of the things that we've had in the law, and for people who are non-lawyers, that this is one of the things that this is not quite legal fiction of saying a PBJ is not a conviction. The feds have sort of found that it is, but mostly found that it is, and so that's caused the problems in the immigration area that has spawned this bill and about 5 years of work on it. Okay?
Okay.
Hi, the Vice Chair.
Well, thank you, Mr. Chair. So first of all, I nominate you to be floor leader on this bill. I think you're going to you'll do a really great job so far.
I'm looking forward to it.
Just a couple things I want to point out, especially for our friends across the aisle. A, to be 100% crystal clear on this bill, this is not a bill about undocumented residents. This also includes and protects lawful immigrants, people here on student visas, people here on H-1 work visas, people here on foreign service, etc. So it's a very broad alternative that's being created here. I have a letter here, and I'm happy to send this around and share it if anyone needs to see it with their own eyes to believe it. And it says MSAA supports the bill with amendments. This is from Mr. Kroll. As long as the consent language is in there, requiring them to consent to this treatment, they are in support of the bill. And if you look at the amendments, you will see state consent. State must consent in the
Page
amendments.
3, Section C,
So
right there.
that law enforcement opposition, you can have a copy of this for sure. That law enforcement opposition is gone. And so with that, last point. This is a bipartisan bill cross-filed with my good friend, Senator West. This bill moved out of JPR unanimously in this form. And our friends Bill Folden, Mike McKay, Mary Delaney James, and the like voted for this bill.
Further questions? We're on the amendment, right? We haven't done any more than that. Delegate Arikan.
Thanks, Mr. Chair. So I think, ultimately it's a policy question for people. Do you feel like somebody who has gotten a green card to stay here and then has gotten a DUI should be somebody who's on a pathway to citizenship, or do we have enough homegrown people who are making really poor choices that endanger our communities. So I'm going to be a no on this bill, even though MSA seems to have changed their position with the amendments, because frankly, we have a lot of our own issues, and I don't like importing more issues. And I think our government, our federal government, has the right to say, this person took a PBJ for a DUI, and we're going to send them home.
Okay. We're on the amendment. I believe there was an amendment in a second. So we'll do this. All in favor of the amendment, please raise your hands. Okay, amendment's adopted. We're on the bill as amended. Is there a motion on the bill as amended? Motion for a favorable in a second. All right, now discussion on the bill as amended. Delegate Cardin.
Just real quick, I think that's a really unique and interesting compromise. The state's attorney is empowered to be able to not allow this to proceed, but it kind of runs similar to a not guilty statement of facts, where the person pleads not guilty, the judge finds that there's sufficient evidence to find them guilty, but stops before that happens, and the person then agrees with the state's blessing to adhere to all the conditions of probation, knowing that if they violate it, they're going to wind up with the conviction, and everything's going to wind up spiraling downhill. So it's a really great way, and it could, in fact, in the future, maybe be expanded to other ways to help lots of different people. But right now, it's going to help this particular group of people, which I think is really great. So I'm looking forward to voting and supporting this bill.
Any further comments on the bill? Seeing none. The Vice Chair? Yes. Yes. Munoz? Yes. Yes. Crutchfield? Yes. Cardin? Yes. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons is excused. Boucher? Yes. Phillips? Yes. Tomlinson? Yes. Arakan? No. Taylor? Yes. Simpson? Yes. Grammer? No. Young? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams? Yes. 19. I'll go back around. If people would like to get on is it amended? Yeah, all right. If you want to get on the bill, just raise your hand. Let me call your name, and then I'll mark you down. Delegates Cardin, Phillips, Simpson, Young, Conaway, Kaufman, and Williams. Okay. It's 193 today. All right. It's moving right along. Are we ready with 859? Are we?
Yeah, but all we have are the Senate amendments, but they're going to be the exact same. So that's been passed out.
Okay, Senate amendments have been passed out for House Bill 859. 859, okay, so there's a cross-filed Senate bill that is, that they offered amendments to, so the same amendments that are being offered to that bill are being offered to this bill, and that's what you have in your packet. Did I get that right?
Yes.
Okay. So there are amendments. There's a motion for the amendments. Could I have a second? All right, so we're on the amendments. So the amendments do several things. Do you want to describe them? Or?
That's fine.
All right. Huh? Yes. On 193? Yes, now we're on 859. And I'm a little sensitive on time. So 859.
So these are the Senate Bill 853. This is the Senate Bill 853 reprint that you have. It's just the same bill except House Bill 859. And the amendments, first they changed the language relating to the private home detention monitoring company's obligation to notify when somebody absconds, and it just strikes out the language saying the designated duty judge of the county. So the agency has to immediately notify the designated law enforcement agency in Baltimore City or county where the court is located, and the court immediately on the court opening for business. And then it creates a new crime, which prohibits a person monitored by a home detention monitoring agency from violating a condition of pretrial release if they are charged with committing certain serious crimes that are listed. And that's a misdemeanor punishable by up to 90 days in jail. And that's very similar to another existing crime on the books, prohibiting a person from violating a condition of pretrial release. And then it creates a work group on home detention monitoring that is required to study the licensing, regulation, oversight, notification, and enforcement processes for home monitoring in the state, and make recommendations for a cost-effective and streamlined process for home monitoring in the state. And that's a 2-year work group.
All right, so that's fine. Discussion on the amendments, please. Delegate Tolles?
Just a quick point of clarification. So on the one we have here, it says does it say Baltimore City on this one? Or is this only Baltimore City?
It's not only Baltimore City.
Okay.
In fact, I think in the original bill, it may have actually left out Baltimore City
Okay.
because it only referred to counties and didn't refer to Baltimore City.
Okay, I'm sorry. I just see.
But yes,
Baltimore City is included in the word county.
that's right.
Say that
But even
again.
still, Baltimore City is considered a county.
Oh, yeah, I know. I'm sorry. I'm getting confused. I saw like the delegation. I saw Delegate Smith. So I'm just trying to make sure that you said it was cross-filed, so it's the same bill on the Senate side. They both the chairs just did it for, okay, yeah.
Delegate Williams thinks
So-
it's a good thing that it applies statewide. She didn't have her microphone on or anything. It's all right.
Okay.
I will say to the committee, and I'll say to people listening, I think there is a broader issue with regard to private home monitoring that we are going to have to take up. But I will also say that I feel like I've been saying this for the last 3 years. We talked about this in 2020 when we dealt with it, or 21, that is, when we dealt with this issue. We dealt with this in 22 when we dealt with this issue, and now we're dealing with it again. I am not a big fan of work groups, but if there is ever a need to actually take apart the problems we have with private home monitoring in particular, we really, really have to do this. And I look forward to our new governor actually appointing people to this work group. Delegate Grammer.
So this does 3 things. It assigns a process for reporting missing persons. It puts in place a penalty for violating, essentially, it puts in place the violation and puts in place the work group. Those 3 things. Am I reading? Okay, thank you.
Further questions? Okay. All in favor of the amendments, please raise your hands. Anybody opposed? Amendments are adopted. Going on the bill. Second. All right, we're on the bill, and there's a second. Further discussion on the bill. Seeing none, the vice chair. Yes. Yes. Munoz. Yes. Crutchfield. Yes. Cardin. Yes. Bartlett. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Boucher. Yes. Phillips. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Young. We can do that. We'll go back around and do add-ons here in a second. Yes for Young. Valentine? Yes. Conaway? Yes. Kaufman? Yes. And yes for Kaufman and Williams? Yes. Yes. Who'd like to add on? Looking around the room. Conaway, Young, okay. All right, the favorable motion is adopted. We are now going to, I don't know why we're getting Delegate Phillips a second bill. This is really troubling. There are no amendments in the second. I'm very troubled by this. I'm not quite sure. I don't know. Maybe it's Maryland winning and winning a game where they're not playing in College Park. I'm a little, I don't know. Yeah. All right, there's a motion for a favorable and a second on House Bill 1032. Okay. Any discussion on the favorable motion? All right, the Vice Chair. Yes. Munoz? Yes. Crutchfield? Yes. Cardin? What was that? Yes? Okay. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Absolutely yes. Quite. All right. And excuse for Simmons. Boucher? Can't do that. I'll give you one yes, though. Phillips? Yes. Tomlinson? Okay, I can't hear very well. Tomlinson, I'm sorry. Thank you. Erican, please. Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Young? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams?
Yes, and if I can explain my code.
You can? Sure.
It's really not much of an explanation. I'm just really happy that Maryland won and beat West Virginia. And as someone who went to University of Pittsburgh and cannot stand West Virginia, I'm really excited right now.
Okay, that's on the bill. House Bill 1077 now, again, with giving another freshman another bill. I don't know what's going on here. House Bill 1077 does not have an amendment. There's a motion for a favorable. Is there a second? All right. We're on the bill as not amended. It's a favorable. Any discussion? Seeing none, the Vice Chair. Yes. Munoz. Yes. Crutchfield. Yes. Cardin. Yes. Bartlett. Yes. Embry. Yes. Pasteur. Yes. Oh, wow. Tolles. Yes. Schmidt. Yes. Simmons is excused. Boucher. Phillips. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Young. Yes. Valentine. Yes. Conaway. Yes. Kaufman. Yes. Williams. Yes. 21. I want to get one in for sure, and it's not expressing a judgment on 1143. I'm going to call 1143 next, but there's one thing I do want to do, and it's involved with me being sometimes very nice. House Bill 1175, Delegate Valentine's bill. I don't know. That was awesome, actually. That was absolutely fantastic. Whole room. Oh, my God. Is there a motion? Is there a motion, Delegate Valentine? Do you have a motion? Oh, fine. We'll move favorable. Do you want a second? Oh, all right. Well, now we're on the bill. We're on the bill. Does anyone have any 14-part questions on this bill? Any questions? Delegate Tolles, do you really have a question, Delegate Tolles? Because if you do, that's fine.
Yeah, I do. I really just got to make sure. What exactly are you hunting?
Is he hunting when? Now?
Is this a honey bill?
It deals, sorry, fair question. Delegate Valentine, tell us what the bill does.
I'm sorry, I should know, but.
I will. I believe that there are certain crimes under the Natural Resources article that this would allow to expunge,
after a certain specified time.
along with other misdemeanors. These are misdemeanor natural resources crimes. Do you remember some of the natural resources crimes that we're expunging?
Yes, such as those crimes requiring an individual with wearing fluorescent orange, having a possession of their hunting license in their possession upon demand, certain regulations regarding obtaining a license and hunting non-game birds out of season without a license and so forth.
So this allows you to get something expunged if you were charged with wearing orange.
If you were not
wearing
for
orange.
example,
Orange.
If you were cited for not wearing fluorescent orange and you were convicted, you would be eligible for an expungement after a certain period of time.
I oversimplified it. I'm sorry. Very quickly, Delegate Cardin.
And I used to work at Mercersburg Academy out in South Central Pennsylvania. I used to teach there. And I went running, and I didn't know I ran into a hunting area as a 22-year-old teacher. And apparently, there were people hunting, and you had to wear orange. And I was not wearing orange, and the police came, and they actually they came knocking at the door of my dormitory, where I'm the dorm parent, and they didn't do anything. They didn't arrest me, but they explained to me that you're not allowed on a hunting range, in this hunting area, without wearing orange. I had no idea. So I am glad. And now if I did that and I got arrested, and I got convicted, I could probably get expunged. Of course, that was in Pennsylvania.
And now you know. All right. Seeing no further discussion on this bill, although, I don't know. So I guess it's a jump ball. The Vice Chair, yes. Delegate Munoz. Yes. Delegate Crutchfield. Yes. Cardin. Yes. Bartlett. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Wow. Schmidt. Can't add on. It's no amendments. Sorry. Simmons is excused. Boucher. Yes. Phillips. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Young. You sure? Oh, yes. Conaway. Yes. Kaufman. Yes. Williams. Yes.
I am very concerned about Bambi and all of the gears and everyone else who will be subjected to this, but I will vote yes for the expungement piece.
And Valentine. Yes. 21. While we're at it, because I'm kind of racing against the clock, I think we're going to have to come back at some point. We have to concur with Ways and Means about something, everybody, and it's a bill from Delegate Kaufman. You guys are really good at that. It's really intimidating, actually. It's really great, cathartic, almost. There is a motion for a favorable and a second. There are no amendments. The bill, as I understand it, well, actually, Delegate Kaufman, why don't you tell us what the bill does, please?
Certainly, Mr. Chair. What the bill does, and let me just preface that this is already done in the great state of Delaware and the D.C. It says that if a parent prevails in a due process claim against a school system, which almost never happens, from 2014 to 2019, it was only 14 cases. But if that happens, a school system must reimburse the parent for expert witness fees, which can cost like $1,500 a day. And it codifies that legal fees, that a school system must pay a parent's legal fees for special education if, in Maryland law, it's already required under IDEA, that this would codify legal fees in Maryland law and allow for the reimbursement of expert witness fees. And it passed Ways and Means unanimously.
There is a motion for a favorable and a second. Any further discussion on the bill? Seeing none. The Vice Chair. Yes. Munoz. You have to think about it, don't you? Yes. Crutchfield? Yes. Cardin? Yes. Bartlett? Yes, she still had to think about it. Embry? Yes. Pasteur? What was that? Yes. Oh, okay. Tolles? Yes. Schmidt? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? This isn't my bill. Oh, you would tell Delegate Kaufman is who, I'm sorry. Yes, you said yes. All right. Delegate Grammer? Yes. Young? Yes. Valentine? Yes. Conaway? Yes. Williams? Yes. Kaufman? Yes. All right. Okay, the chair votes aye out of 22. Oh. All right. I need to do one more, and then I think we're going to get the bells, and that's the best I can do. We're going to come back. I'll let you know when we're going to come back, but at the moment, we're going to keep going with House Bill 1191. House Bill 1191 is Delegate Pasteur's bill because now she's showboating. So we're going to do this one. There is an amendment. There is an amendment. There is an amendment. There's a motion for the amendments. Is there a second? All right. The amendments appear to add representatives because I got contacted by, I think, 4 million people who want to be on this task force. God bless them all. All right. It adds the Montgomery County Department of Health and Human Services, the Maryland Children's Alliance, a representative of Bankers Association, and a representative of the Maryland Mental Health Association, or Commission. Is that correct, Delegate Pasteur? The Maryland Healthcare Commission,
Yes.
the Bankers, the Children's
That's correct.
Alliance. What? Yep. And then a representative of the Montgomery County Department of Health and Human Services. That's those are the amendments that you have? Okay.
Yes, sir. Yes.
Any questions about the amendments? We did that, and we've got a second. Yeah, that's great. All in favor of the amendments, raise your hands. All right. Anyone opposed to you are all in favor of the amendments, I assume. All right, well, I can't assume, so all right. Anybody opposed? All right. The amendments are adopted. We're on the bill. Motion on the bill, please. There's a motion for favorable in a second. Any further discussion on the bill as amended? All right, just to be clear, after this, we have to stop. We're going to run out of time. We've got to get to the floor. So I'm calling first Delegate Kaufman.
Yes.
Yes, thank you. Delegate, the Vice Chair.
Yes.
Yes. Munoz. Yes. Crutchfield. Yes. Cardin. Yes, and add. And add Kaufman, and add the Vice Chair. We'll go getting there. Bartlett. Yes. Embry. Yes, and add on. Pasteur. Okay. Tolles. Yes, and add. Schmidt. Yes, and add. Boucher. Oui. Phillips. Yes, and add. Tomlinson. Yes. Erican. Yes, and add. Taylor. Yes, and add. I've got them all. Simpson. Yes, and add. Grammer. Yes. Young. Yes, and add. Valentine. Yes. Conaway. Yes, and add. Motion is adopted. Oh, wait. Williams. Sorry. Yes, and add. Williams is a yes, and add. Chair will vote yes. Add Crutchfield. Add Munoz. All right. Thank you all very much. We will announce a voting session, another voting session at some point. We'll figure it out.